Assalamu alaikum. Welcome to I Beg to Differ. My name is Yusuf Ismail. This is a program which focuses on contemporary debate on socio-political, international and current issues contemporaneous to the broader South African public. Over the past 20 years, there has been an inherent move to regulate Muslim personal law, and this process has seen a great degree of opposition from numerous quarters. More recently, the Women's Legal Centre Trust brought a consolidated application in the High Court in Cape Town, together with two other applicants, against a number of institutions and bodies. And this judgment has had far-reaching implications. Well, joining us in the studio today, we have Mr. Muhammad Shoaib Omar, who is an Islamic jurist and an attorney who's been involved in the whole process of Muslim personal law for the past 20 or so years. Welcome, and thank you for the program. Thank you for coming to the program. Just to start off, Mr. Omar, this judgment, this application basically, I do believe that in 2009, the Women's Legal Centre Trust brought an initial application for purpose of accessing the Constitutional Court, and I do understand that the then erstwhile Judge Cameron rejected the application. What was the basis of that?
Well, that was an application brought by the Women's Legal Centre Trust. It was brought directly to the Constitutional Court. And the purpose of that application was to compel the state, to compel the president to perform his constitutional obligation in passing an appropriate law recognizing Muslim marriages and their consequences. And the Constitutional Court didn't consider that application on its merits. It rejected, it refused to grant any relief because it was of the opinion that a matter of that nature with such sensitive and far-reaching implications should be accessed first through the High Court, and then it should go to the Constitutional Court.
So they brought the application recently, this judgment, and I've seen the relief that they, but just to clear, what was the essential relief that the Women's Legal Centre of the recent Cape High Court judgment?
The essential relief was a narrow one, and that was to compel the government to pass a law recognizing Muslim marriages and their consequences.
The bill apparently takes us back to the medieval period of coercion with the state taking sides on religious doctrine. Do you think that's well-founded in the sense that there are certain definitions within the then existing bill and obviously the subsequent amendments to the proposed bill? Do you think that there's a direct kind of impositional relationship that the state then has with the Muslim community had this bill come into act?
To understand that contention, firstly, that contention in my humble opinion is not correct. To understand that contention, you've got to look at the existing situation, right? As matters stand at the moment, Muslim or Muslim spouses, right, have two options. People who are married in terms of Sharia law, in other words, the normal nikah, they have to, if there are problems in that marriage, if there's a talaq or a separation or a dissolution of that marriage, or if the wife wants a fuss, there are two options. The one is you have a viable statutory framework to regulate those consequences, so that you have a statute and you have recourse to the statute, and then you have a degree of certainty, and that statute will be the basis for determining and adjudicating the dispute from point one, from the beginning to the end. Right. So, for example, if a man in Cape Town is married in terms of an Islamic marriage, he has two children, he talaqs his wife and comes to Durban, relocates and just ignores his children, ignores all his obligations relating to maintenance and so forth, and the welfare of the children, then you have a statute that will regulate that, right, in a viable, practical way. That's the one situation. Because absenting that statute...
So it provides a kind of a protectionist mechanism at the same time.
To protect the woman, to protect the children, right? That's just one example. As opposed to the other option, which is if you don't have that viable framework, statutory legislation, and just leave it to the couple, then the wife, subject to a means, will have to go to court, right, and invoke certain remedies.
And seek relief in the normal course.
But there's no third option. In other
Yeah.
words, to answer your question now about whether by legislating on Muslim marriages there will be an intrusion in the religious domain, that would have made sense if there was a third option to stay out. But there's no third option to stay out. Either you're going to get these individual cases that we are getting with a case-by-case development which is chaotic, uncertain, with conflicting decisions, potential conflicting decisions,
Yes.
or you have a viable framework. So essentially what you're looking at here is which is more beneficial to the community. Either you stay out, remain within the status quo, but you're still in. You're regulated by the law.
But that's the point is, and I think it's ill-founded in many respects, is that a lot of the opposition stemmed around the fact that some concepts, and again, we can debate it, such as talaq, fasq, khula, that these were in fact gender specific. And by virtue of the fact that they're gender specific, they wouldn't meet up constitutional muster, meaning that at some point in time, you have an aggrieved woman or a couple, for example, that comes to court and says, this is totally unacceptable, I cannot buy this. And so their fear was that if this dispute is then taken to the highest court, certainly, obviously the limitations clause obviously applies, but if something which is viewed as gender discriminatory, that would be struck. So that would have been the inherent fear that they had. And so the argument is on that basis, because of the kind of incompatibility of the two systems, you cannot prevent a potential situation occurring in the maybe immediate future where that could probably occur.
Look, that is an argument, right, to consider. But the answer to, there are two answers to the argument. The first answer is we can't get, if you have legislation, right, which is substantially Sharia compliant and ring fenced, right, so you can't have an absolute protection around that. I mean, there's always a potential for constitutional challenge. Right, so that's the one part of it. The other part is, as you and I speak now, right, still the Constitutional Court has jurisdiction to set aside any principle. For example, let me give you an example, like you had the Indian triple talaq situation.
Which is now, I've seen the new reports that have, and I'm going to zero in on that, but apparently it's outlawed. That if the media reports are correct, a few days ago, that's been totally outlawed.
Yeah, so what I'm saying to you is, if you take, let's assume you have a problem here in South Africa without a statute, despite all these, let's assume we accept the argument that, okay, we don't need legislation, leave everything as it is, let the status quo run. And then you have a dispute between two parties, and the husband then issues a triple talaq just on one occasion, and that's the end of it. He terminates the marriage, right? Now, nothing precludes the wife to go to court and challenge the triple talaq and say it's unlawful.
And she's got the right to do that.
She's got the right to do that.
Absolutely.
Constitutionally, she has jurisdiction. The courts are not going to abdicate their jurisdiction. All marriages, whether you have specific legislation or not, enjoy the protection of the Constitution.
Well, that goes then to the root core of the issue, is that the bill as it existed, even though there was inherently a lot of opposition to it, but the bill, as I recall and having read it over the years, was an inherently conservative piece of legislation. And, you know, to some extent, obviously you could disagree with me, lazy, not in the sense that there wasn't any effort being put into drafting that particular bill, but lazy in the sense that essentially you had an opportunity to truly draft something which possibly could have encapsulated ethical Quranic paradigms, but in many instances you kind of had an amalgamation of the different schools of thought, where you have the Maliki school of thought, the Hanafi, the Shafi, the Maliki, and it was just simply an amalgamation of jurisprudence. So from that perspective, do you see this perhaps maybe that back then, you know, with the inevitable opposition that had come, that this was a lost opposition for Muslim jurists and for the legal minds to truly engage in what we would call ijtihad and truly come up with something which is potent. I mean, the triple talaq formula, I mean, this, I remember coming across this years back, and for me, the whole notion is nonsensical. I mean, even among certain Islamic thinkers, people like Ibn Taymiyyah, and from the Quranic perspective itself, that there is no validity to this idea that someone can just simply divorce someone easier than eating peanuts by just simply repeating triple talaq. Yet that found itself, that was incorporated, the talaq-e-bain was incorporated in the bill itself.
Yeah, but we didn't incorporate. Let me tell you about the bill. Some of the more progressive points of the bill. They were progressive, but yet within the overall framework of the Sharia. Triple talaq-bain was dealt with, but not triple talaq per se, because triple talaq, obviously, as you say, is a different issue, and now it's the subject of legislation in all the Muslim countries, where all the Muslim countries have legislated and they've adopted the viewpoint of a significant minority of jurists. They're significant. It's not only Ibn Taymiyyah and Ibn Qayyim, but there are other scholars, jurists, who believe that 3 talaqs pronounced on one occasion constituted one talaq. So that's now been legislated in those Muslim countries. And that falls within the principle, well-known Sharia principle.
Well, I mean, the United Ulama Council of South Africa accepts the validity of a triple talaq, which you represent. I mean, most of the ulama bodies, including the body you represent, in fact, still accept the validity of the triple talaq.
Yeah, they, for example, if it's KwaZulu-Natal and what now, Transvaal, who apply the Hanafi mazhab, they accept the validity of the triple talaq because the triple talaq has been accepted by all the 4 schools, right? There's a consensus on that as far as the 4 schools are concerned. But that issue has never been ventilated. You see, let me give you another principle. The Muslim countries that have adopted the viewpoint of Ibn Taymiyyah and others, whether it's all the Muslim countries, and they legislated that, because the triple talaq issue is an ijtihadi issue, there's a difference of opinion amongst the jurists, classical jurists, on this, whether 3 equals 3 or 3 equals 1. If the issue is an issue of ijtihad, and if the state adopts the one position, where there are differences of opinion, then that position becomes the dominant position in that community. And it's, the classical jurist calls it rafi'un lil khilaf. It dispels the difference. So it's for the state to adopt the one position, and then in the context of the difference of opinion, and then that opinion becomes the... So now, coming back to the point you raised earlier on about the progressive elements of the bill, you see, the triple talaq was not, the talaq-e-bain was dealt with, right? It was defined.
Well, talaq-e-bain,
it just means
effectively the same thing. I mean, in many respects. Talaq-e-raj'i is the talaq in the conventional Quranic framework.
But what happens, it only becomes bain after you give the 3 talaqs on different occasions.
But what I'm saying is that there was a provision in the bill which enabled that process to occur.
No,
what was the need for that?
The bill just defined a bain. A person can give 1 talaq, and he can give it in the form of a bain talaq, right? Which just means there's no more raji, it's bain, and the parties can still reconcile by going through a nikah, right?
Well, I just want to stop you there. On that point. We're going to come back shortly. Just hold that thought, Mr. Omar. We'll come back shortly. We have to go for a quick ad break, and we'll be back. Welcome back to I Beg to Differ. We're discussing Muslim personal law. Now, Mr. Omar, just before we went for the break, we focused on the issue of the triple talaq. And my understanding, having looked at the bill, was that talaq-e-bain somehow or the other incorporated that particular type of practice. You said that that was not indeed the case. Just to clarify that position, did the bill in fact make provision for the validity of a situation whereby if a husband, for example, proclaimed talaq 3 times or 1,000,000 times, that she was finally viewed as divorced and it was viewed as irrevocable divorce, or was that still viewed as a revocable divorce?
No, the bill doesn't deal with the issue of triple talaq per se. Right. It has certain definitions, like talaq-e-bain, that was necessary within the context of the law. And then it's got a definition for fas, the grounds for the dissolution of a marriage where the husband doesn't...
Deserts,
for example, or where the marriage is irretrievably broken down in terms of Maliki fiqh, it's called shikak. In fact, that's quite a progressive position because in terms of Maliki fiqh, in terms of the Hanafi school, the grounds for dissolution of the marriage are very limited and narrow, for example. But where the marriage is broken down irretrievably, right, the grounds for a dissolution or a fasq is very wide in terms of Maliki fiqh. So some of the provisions of Maliki fiqh were incorporated, just as in India, in the Dissolution of Muslim Marriages Act, the leading ulama of India, including the Jamiatul Ulama of India, Hind, they supported legislation, Dissolution of Muslim Marriages Act 1939, which incorporated the Maliki provisions of fasq.
So a degree of flexibility.
There's a degree of flexibility. So we incorporated the Maliki provisions there, some of the Maliki, like more particularly the question of an irretrievable breakdown where all the foundational values of a marriage are destroyed. Parties are totally incompatible. The husband is not giving a talaq. The wife has the basis under the Maliki school to have that marriage terminated. Right. So that is so that comes under the shikak. Shikak is a Quranic word. Shikak.
Yes.
Right. Now there are other provisions in the book. For example, upon dissolution of a marriage, the judge has the power in his discretion when it is fair and equitable, but absenting agreement between the parties. Let's take a situation where the assets of the marriage are all co-mingled. The husband is pooling his earnings, the wife is pooling her earnings, everything goes into one pool and they buy different assets. They buy household furniture, they pay the bond, all that. One asset is in the one spouse's name, the other asset is in the other spouse's name, but the source of those acquisitions are the joint earnings. So it's called co-mingled, right? What we call in technical Sharia language, makhlut. So in that situation, the parties must agree upon termination of the marriage as to how to divide that. But if they don't agree, then the judge has the power to redistribute, to make an equitable division or apportionment of those assets.
See, so based on that then, and taking it out further, just by extension, when people were, for example, contending that this bill was limited in the sense that the definition of who a Muslim was, for example, was specifically limited to those who, I don't like using the term, but those of the Sunni community, or those who traditionally subscribe to the Ahl Sunnah wal Jama'ah. And one could argue, what about the Shiite community? We've got a substantive minority in this country, or people who, for example, are the Ahmadi group of Muslims. They would designate them as Muslims. How would you define then? I mean, had this come into place as a legislation, how would they have been incorporated into the bill? Would they have to invoke the provisions of the clause? Who would define? Because the definition of Muslim was extremely arbitrary from the bill's perspective.
The bill was not designed to deal with all the detailed issues. It just gave you a framework.
So who would be left with the detail? Who would provide? On
a case-by-case basis, if there were specific situations, because it was not intended to be a code of Sharia law, the bill. The bill was just giving you a framework.
A skeletal outline. A
skeleton outline with certain definitions, with a process of compulsory mediation, voluntary arbitration, court adjudication, and there were certain uniform principles that had been incorporated in the bill. It wasn't designed to be a code. Right? You can have different positions or different permutations. You could have a minimalist option, you could have like a middle of the road framework,
or
maximalist option with a proper code of Sharia law and so forth.
So in terms of application, and we would argue who was that bill for? Was it there for Sunni Muslims? Was it there for Muslims from the generic perspective? Shiite Muslims, Ahmadi Muslims?
The bill was there for Muslims, right, as defined there. That is primarily the Sunni.
Well, those who basically, it doesn't state
those
Sunni, but those who believe in one God.
The usual, yeah. It doesn't use the word Sunni to the best of my recollection. Now that bill went through several processes, very extensive consultative processes. First, within the confines of the Law Commission, they have their own requirements. A lot of input was received. Then when the bill was finalized and approved by the Law Commission, again it went through consultative processes, workshops, and consultative. And then ultimately the state made some amendments and recirculated it for public comment. So it's been through so many processes that ultimately it reached a point. Now, then it got aborted, as we say. That just the government lost the will for some reason.
But there was
maybe the opposition may have been the.
Was there influence by the opposition at some ministerial or governmental level that just totally derailed the process? Because something happened. Something
Correct.
did happen. It had reached a zenith, its peak, and then suddenly
at some stage the government made a promise to have the bill enacted.
And
at
it
one
never
point,
happened.
The Deputy Minister of Justice, when he was then the Minister of Justice for a short while, and then he studied the bill and had a meeting with interested parties and said, I'm now ready to move forward with the process. And before that, it was pre-election, and after the election, his portfolio position was moved. So it came to a point, it was ready to go through cabinet approval, may have been approved by cabinet, I'm not sure, go to parliament, various processes and so forth. And then it got aborted at some point, and then the government lost the will to proceed with
that.
Now, the current deputy...
So the Women's Legal Center Trust then, not surprisingly, took it upon their own initiative
Correct.
to move and spearhead the process.
Correct.
Which they should be commended for.
Yeah, the Women's Legal Center Trust did it because it's...
Well, why did the United Ulama Council, and the reason why I'm asking you is that they were an amicus in this entire process.
Okay.
Why were they so, why were they so in a sense acquiescence, or were in a sense in a limbo and did not spearhead the initiative? You had another body, an independent body.
Look, to be honest with you, they should have done it.
And they didn't.
They didn't do it, and I think the fault lies with them. I'm being honest with them for being lax in this process.
A lackadaisical approach.
Lackadaisical. This kind of legal challenge requires a lot of funds and commitment and so forth. Whereas on the other hand, the Women's Legal Center Trust is a non-governmental organization, and they sing a lot of the problems on the ground, more particularly in the Western Cape, where vulnerable women are coming to them on an ongoing basis with their problems. So they took up the cudgels and said, we'll bring the challenge. And fortunately, they had a team of lawyers who was willing to assist within the even within the Women's Legal Center Trust and outside.
I get the sense that there was a kind of a power dynamic at play, and the sense I get is that somehow or the other, and perhaps even amongst the United Ulama Council, there was this kind of inherent fear, and perhaps that may have been a reason for their non-engagement in the process after the whole bill was derailed, was that perhaps from their perspective, or the general religious establishment, they saw this as a sense whereby their power, or their so-called spiritual stranglehold over the community would be wrenched away from them. I don't know if you can call it harshly put, and no longer be in the decision-making process which they have been for many years.
Well, I think
that could have been a factor.
That has been a fear in some quarters, no doubt about that. If you read some of the early what you call comments, that inputs that have come through, and more particularly the one you mentioned in your what you call earlier on, you quoted
Ziad Mutala's.
It
was a pseudo-academic blog.
See, what they tried to do there was to separate that, say, look, keep the religious issue within separate within the Jamia, to let them control it. But what they're missing there, the point they're missing is, in fact, the bill would have empowered the ulama fraternity, because now, previously, they don't have any, whilst they're in control, but they don't have any legal mechanism to enforce their rulings. For example, if a woman went to a judicial body, Muslim judicial body, to a Jamia, to MJC, and said, look, my husband is not, he's just talaqed me, he's not maintaining me, I've got these children. And then that body does an investigation, calls the husband says, I'm not coming to meet you, you don't have any jurisdiction
There's
over
nothing
me.
to basically...
Or alternatively, it does go and they give a ruling and say, okay, you must pay maintenance.
How do you enforce that?
How do you enforce that? So there was no enforceability.
No contempt
and
proceedings, nothing.
law is meaningless if you don't have an enforceability. Even in the seminal letter, if you go into history, when the Muslim judiciary was established, and Hazrat Omar radiallahu anhu, as the second caliph, sent his first seminal foundational letter to Qazi Shurayh, he said there, he said, look, enforceability is the key to all this. There is no use speaking about rights and obligations if you can't enforce them. So this was the point, that those who thought that they wanted to retain the power within the local judiciary, they're not losing the power, they're getting more empowered because they will come within the bill now. And so what they need to do really is to upgrade their own skills now. So they'll have to go for training. They need to
basically go for training,
run
judicial training,
correct,
understanding
how
of
the
Islamic law
of qada applies and all the details. These are specialist areas, so they need to know how to run a mediation, how to
arbitration, and how to basically enact litigious disputes between couples. I'm going to have to stop you there. We're going to go for a quick ad break. We'll be back shortly. This is I Beg to Differ. Welcome back to I Beg to Differ. We're discussing and debating Muslim personal law, and with me in the studios is Mr. Shoaib Omar. So now, just before we went for the break, I had to stop you and interrupt you there. One thing which I still want to go back to is this issue is that from my perspective, many people out there, is that the bill was certainly in many respects an amalgamation of jurisprudence. Because, you know, one of the issues, and I think this needs to come out clearly, is that and this has been raised by a number of Islamic thinkers. One that comes to note is Ziauddin Sardar. People assume that in actual fact there's a tampering of Sharia, whereas Sharia in fact is a very generic concept. And what basically is under the rubric of Sharia is essentially fiqh, jurisprudence. And jurisprudence is purely the juristic interpretation of classical jurists. That's not divine. That aspect is not divine. Yeah. So the argument that Sharia is being tampered with, it's a very mundane, weak argument, because in actual fact what we are looking at is the existing jurisprudence. And this takes me to the next level. Don't you see it as problematic? I mean that not just in the South African context, but globally, when it comes to, for example, the implementation of Muslim personal law and perhaps aspects of criminal law and the broader ambit of running the state, generally speaking, Muslims again adopt this lazy position of inertia whereby they just simply rely on the regurgitation of jurisprudence that developed in a particular context. I mean, we talk about the Maliki, the Hanbali, the Hanafi, the Shafi madhab, but I mean, this evolved in a particular context. And we don't have a situation of a new jurisprudence. I mean, shouldn't this have been an ideal opportunity? I mean, taking into account there was inevitably going to be a degree of opposition, that this should have been an opportunity to say, look, let us sit down. Maybe we need a total overhaul of the fiqh. Maybe let's just go back to the primary source, the Quran and the prophetic paradigm. Let's utilize the source, the foundational absolute reference frame, to develop the law that is contingent with the time and the period and the epoch that we are in.
You see, it's a good point you raised, but you've got to look at some aspects of this, right? Firstly, when we speak about Sharia, we've got a small minority of rules which are absolute, right? That's in terms of the Quran and Sunnah.
Very few laws in the Quran, in fact, small absolutes.
They are absolutes, they are unambiguous, you can't do anything.
But the rest is...
Now, the rest are dynamic. And within the dynamic sphere, you've got, for example, juristic interpretation from the primary sources, right? Now, when you have different juristic interpretations, right, what we call ijtihadi interpretation, they need to be permissible for collective benefit, to select a rule of a particular mazhab, which is most
conducive,
or which is which fits
but
the
what
particular situation. Right.
But why
So
rely
here,
on
that's
that?
why the first thing is you go back to the classical sources. If there is a juristic rule which is useful, which is practical, which fills that vacuum, that contemporary vacuum, then you would take that rule because it's a recognized, reliable method of interpretation from the original sources.
Why so much primary reliance on the classical source? There's a lot of reliance.
It's a basis to go forward.
But I mean, you've got your absolute
if you
reference
don't
framework
know,
there,
so
the Quran and the Sunnah.
Yeah, you've got your primary reference, you've got the narrow, the inner circle, the narrow minority rules which are absolute. Then you've got the dynamic component which is flexible. Then you go to the third level now. And the third level is what you're speaking about, is where you don't have an answer to a specific situation. Or in the context of a minority where you're living, where what we call in technical language fiqhul aqalliyat, the fiqh of the minorities. So then what you do, then you need some competent jurists to get together on a collective basis and to interpret and find an appropriate solution. Again, link back to the primary sources of Quran and Sunnah. And this is called al-istihad al-jama'i. Collective ijtihad, like what they have done now with the Global Fiqh Academy in Jeddah, which started in 1983. They haven't dealt with Muslim family law. They've got so much of work to do, but primarily in commercial matters and medical legal issues. They competent jurists representing different Muslim countries have got together. In fact, these are super Sharia experts, right? Super specialists in Sharia, got together and they've submitted papers and debated issues and ultimately taken resolutions. So that's another facet. There's different processes. All that this bill was designed to do at the inception was to create the framework to move forward. It was not designed to deal with all the details because there was a phase 2 and a phase 3 and a phase 4 as matters developed, right? But it got aborted in phase 1 because if we went to phase 3 in the beginning, then there would have been absolute chaos. People would have said, you're using ijtihad, you're misusing ijtihad, and so forth. That's why the process was so sensitive. I mean, we consulted with top jurists internationally. My first teacher,
Mufti Taqi Usmani.
Before we come to even my second teacher, Mufti Taqi Usmani, my first teacher, the Qadi of India, was a world authority in Muslim family law, Qadi Mujahid al-Islam. We called him to South Africa on 1 or 2 occasions to discuss with the local scholars, to create a détente, to explain to them why there's a need for proper statutory legislation, how to address these issues. So then we brought Mufti Taqi Usmani down. He came. Then we consulted the Islamic University of Islamabad, Dr. Mahmoud Ghazi, and his team came down. Then there were Saudi scholars and so forth. So a wide range of ulama and top Sharia experts were consulted in moving this process where the bill was discussed with them. And there was a consensus amongst them that there's a need for statutory legislation. In fact, Mufti Taqi Usmani himself, when I had approached him, he spent 1 week going through all the arguments and counter-arguments, and he wrote a paper in Urdu. It's in detail and it's been translated.
And did he engage some of the opponents to the bill?
He did engage, but unfortunately,
and what was the outcome?
you see, the problem with this issue is the opposition from the local ulama, some of them who oppose. I think the problem there is, and with the greatest respect to them, whilst they may be good general practitioners and sincere people, to understand something at this level, which is highly complex. Here, there are 2 laws involved. You've got to be a Sharia expert, you've got to be a legal expert to understand how this process is being integrated and why it's being integrated. It's not so simple.
There's a lack of know-how.
It's a lack of know-how, lack of understanding, lack of perception. You see, they think, and this is the point I'm trying to emphasize all the time, but nobody, more particularly from the ulama circles, they haven't understood it. Mufti Taqi Usmani, when he came down, explained this to them. What is the default situation if you don't have the bill? What is the default? The default is the Muslim men and women will still go to the court.
Sure.
If some scholar or alim or whoever in some part of the country says he has a problem with his wife and says, look, I don't accept the constitution, I don't accept any bill, I'm not interested in this process. I'll do what I believe is correct from a Sharia perspective. He has that choice. But remember one thing, if his wife goes to the maintenance court and sends him a notice, that man will have to go to the maintenance.
Sure.
He's not living in an island outside the law. He's within the law.
The framework of the
so
law.
this is what they don't understand.
But the bill did allow.
So either you're going to have case-by-case development in a chaotic, conflicting, non-Sharia compliant way, or you have a viable statutory framework, which is the best you can do. We can't do anything better in a secular society. And the principle, I always say from classical jurists, the maxims that we use, one of the maxims is akhafud dararain, the lesser of the two evils, or the other maxim is you compare the benefits of legislation with no legislation, right?
And look at the negative ramifications.
And say which is better. Yes, this is not perfect statutory system, but it is much better than not legislating. I mean, recently I had a case where the parties were in a Muslim marriage because there was no framework legislation. The husband had contributed towards the acquisition of the matrimonial home, but the property was registered for certain purposes in the name of the wife. When the marriage broke down, the wife said, it's my property. And the husband said, I want my share back. What about at least, I paid for, made a substantial financial contribution towards the property. So there is no, how does he devise a course of action? So he issues a summons and says, no, my wife held the property as my nominee. Right, I'm the true owner, which was not technical. He had to use a common law paradigm or construct to create a course of action, but didn't help him. If there was a viable statutory framework giving the judge the power to do an apportionment in the absence of an agreement, this was a classical case where the judge would have looked at all the factors and said, if you can't reach agreement, at least I'm returning this man's contribution. So he would have taken her contribution, his contribution, done a holistic evaluation and made it financial award. So it would have been an equitable redistribution.
I just want to bring up the other issue is that, and one of the critiques leveled against us is that Muslim personal law, in all its manifestations, has been inherently patriarchal. Do you agree with that contention? That there is certainly a level of patriarchy, and that level of patriarchy was not addressed by the project committee. In fact, they lean too much apologetically towards the side of the conservatives.
Before we even deal with the patriarchy issue, right, we must understand now, as we are speaking now today, forget the Muslim marriage bill. That's now, in a sense, it's there, but it's almost like you can say it's a history. Now we have, because the Muslim community couldn't reach consensus,
you've got another
because the ulama couldn't reach consensus. That bill was under the control of UQSA. It reached a point where UQSA was in control of the process. Now they've lost control. Now you've got a new process that has triggered in. This process means, in terms of this judgment, which will probably go to the Constitutional Court for, if you want to call it, confirmation, and they will confirm it with certain now there's going to be a new process, right? And I'm open to a new process. We have to keep our minds open. If there's a better process or a better, but remember one thing, it's not going to be the same as before, because there will be different role plays, there will be different people who will have to be consulted, and there's no guarantee that what you got on the table is necessarily Sharia compliant.
Well, I'll have to leave it at that. I wish we could go on for much longer, Mr. Omar. I want to thank you for participating in this discussion. It's been a pleasure having you. We hope to have you again in the future. Well, you've been watching I Beg to Differ. This is a program which focuses on interactive and contemporaneous debate. And join us next week for more hard-hitting debate. This is Yusuf Ismail from ITV. Till next time, Assalamu alaikum wa rahmatullahi wa barakatuh.